Today in this video we are going to discuss about Article 12 of Indian Constitution. As you all know, Article 12 it gives you definition of state. Now Part 3 of Indian Constitution, right? It starts with Article 12 and ends at Article 35. We all know that Part 3 it deals with fundamental rights, right? Fundamental rights, they are negative obligation on state, meaning no action of state should violate fundamental rights of citizens. So, but what is state for Part 3? Who shall not violate fundamental rights? This definition of state is given under Article 12. I hope you are clear with what are we going to cover in this particular topic, right? So, Article 12 it defines state. The definition says for this part or in this part, that is Part 3, unless the context otherwise requires, the state includes government and parliament of India, government and legislature of each of the state, all local authorities as well as other authorities, right? So as per the definition, there are four entities of state, that is parliament and government at central level. Second, state legislature and government at state level. Third is local authority, and last is other authorities. So first point is very clear that Parliament of India, state legislature at central level as well as government of India, these are considered as state for Article 12. Then state legislature as well as government at state level, these are also considered as state. Then local authorities. So all such authorities which perform local governance, for example rural local bodies as well as urban local bodies, they are also part of state under Article 12. And last thing is other authorities. Now this other authority, this question which all authorities will be considered as other authorities, this question has been answered or interpreted, this thing has been interpreted by Supreme Court of India in various of its judgment. So we are going to discuss various Supreme Court judgment or cases to understand what all can be considered as other authorities for the definition of state under Article 12. So firstly, this question it was taken up by Supreme Court in a case called as Rajasthan State Electricity Board versus Mohanlal and others case 1967. In this case, the question which was which was there in the front of Supreme Court was whether the State Electricity Board of Rajasthan can be considered as a state under other authorities under Article 12. Here, Supreme Court said because the State Electricity Board has been created by a statute, by a law passed by a state legislature, this will also be considered as other authority under Article 12. More comprehensive definition of other authorities was given in a case which is famously remembered as R.D. Shetty versus International Airport Authority of India case 1979. Here, Justice P.N. Bhagwati of Supreme Court of India laid down 5-point test that if a authority is fulfilling any of these 5 criteria will be considered as other authority under the Article 12. So first of this point is that if that entity is getting financial aid or is substantially controlled by the state, then such a authority will be considered as other authority or will be considered as state. Meaning, if a authority is getting financial aid from the state, significant financial aid from the state, then such a authority will be considered as state authority or state. Second is, if state has deep and pervasive control over that authority, meaning in the decision making of that authority, if state has a significant role to play, then also that authority will be considered as state. Thirdly, the Justice Bhagwati said, if a particular entity or authority enjoys monopoly status, and that too that monopoly status has been conferred to that authority by state, or that monopoly status has been protected by state, then that authority will be considered as state under Article 12. For example, let's say RBI. RBI has been given the monopoly over regulation of all the banks. No other authority can regulate scheduled commercial banks in India, right? This monopoly has been granted to RBI by state. Yes, so such a body will also be considered as state. Then public function. If a authority performs such a function which is otherwise generally performed by state, such authority will also be considered as state under Article 12. For example, if a private body has been given a task of public safety. Now, public safety, it is generally a work of, or it is a public function, it is a work of government, right? If a private entity is also doing it, this entity can be considered as state. And the last condition, which was put by Supreme Court in this case is, if state has a role in the establishment and functioning of that particular authority. For example, just now we have seen, in the previous case we have seen that the State Electricity Board of Rajasthan, because it was created by state, because it was created by a law, that was considered as state. Similarly here, if state has a role in establishment, for example LIC, LIC has been created by a law passed by parliament, right? And hence LIC will also be considered as state for the under the definition of Article 12. So I hope it is clear to you when we can consider a authority as state under Article 12. So these are the 5 conditions which are very comprehensive given by Supreme Court in R.D. Shetty versus International Airport Authority of India case 1979. The next question which comes in the same article is whether judiciary is part of state or not under Article 12. So you see, Supreme Court, it has anyhow answered this question multiple times, but in a very famous case again, Rupa Ashok Khurra versus Ashok Khurra case 2002, Supreme Court clarified whether judiciary is part of state or not under Article 12. Supreme Court said that under Article 12 specifically does not mention about judiciary. It only talks about these 4 things: parliament, government, state legislature, government of state, local authorities and other authorities. Right? It does not mention about judiciary. Supreme Court said the purpose of Article 12 to define state is that these bodies should not violate fundamental rights. On the other hand, the role of judiciary is to protect the fundamental rights of these people, citizens against state. So, hence it is presumed that judiciary cannot violate fundamental rights of citizens, because the role of judiciary is to protect the rights of citizens, right, not to violate it. And hence Supreme Court in this case again reiterated its position that judiciary will not be considered as part of a state under Article 12. Supreme Court further said when judiciary is performing judicial role, it shall not be considered state. But when judiciary is performing some administrative role, for example, let's say judiciary is hiring employees, then in such a case it is not performing judicial role. Then in such cases judiciary can also be considered as state. Meaning, for example, under Article 15 and 16, the provisions of reservation are there. If judiciary is also hiring for lower judiciary employees, then in such a case judiciary also has to give reservation, right? Because while performing administrative role, judiciary can be considered as state. I hope definition of state is clear. There are 2 things to remember. One is judiciary while performing judicial role is not part of state. Second thing is under Article 12, this definition of state is only valid for Part 3. That is for fundamental right, not for other parts of the constitution. But another thing, under Article 36, Article 36 which starts, which talks about DPSPs, Article 36 to 51 is Part 4 DPSPs. Under Article 36 it is mentioned that the definition of state for Part 4 as well will be same as under Article 12. Meaning the definition of state under article which we have seen just now, it is applicable for 2 parts, Part 3 and Part 4, not for any other part of the constitution. Yes, so I hope the definition of state is clear to you. Thank you so much.